We're going to open the public meeting. Our first order of business is public input. Public input shall be limited to statements from the public relating to issues with the jurisdiction of the... Can I have a quiet, please? Public input shall be limited to statements from the public relating to issues with the jurisdiction of the Chelmsford Zoning Board of Appeals that are not currently the subject of a pending public hearing before the Zoning Board of Appeals. Public comment on any pending public hearings shall only be heard during such public hearings and may be limited to 3 minutes' time. Is there anyone that would like to speak tonight
Yes, I would.
regarding?
Riverneck Road.
That's on the agenda, so we will not be hearing that. Yep. Outside of the agenda. We have a new public hearing, 243 Riverneck Road. 243 Riverneck Road LLC and its manager, Ashok Patel, are requesting a comprehensive permit pursuant to Mass General Law, Chapter 40B, for a property located at 243 Riverneck Road. The property consists of 7 single-family dwellings for sale and 16 townhouses for rent. Of the total 23 housing units, 6 units will be designated as affordable housing, consisting of 2 single-family and 4 townhouses. This property is located in the residential RB district. At this time, I'd like to make a statement that the town is going to invoke safe harbor, having the required amount of low-income housing for the town. And I'm going to turn it over to Carolyn Murray, to our attorney, to speak on that so we can understand it better.
Thank you, Mr. Chair. For the record, Carolyn Murray from KP Law, your town council. Just a little over a month ago, I was meeting with this board, but not necessarily all of the same members, when another 40B application was before you. And that night, you had, as you do this evening, a memorandum from the Director of Community Development explaining where the town stood in terms of achieving one of the safe harbors under 40B, and in particular, the 10% threshold. You have, again, in your packets this evening, a memorandum from the Director of Community Development explaining that the subsidized housing inventory that's maintained by the Executive Office of Housing and Livable Communities is the number of affordable dwelling units that the town has registered with the state. If you look online, the SHI is updated as of March 26th of 2025, and that shows us just below 10% at 9.94%. However, subsequent to the posting of that SHI, there were 2 more projects that came online. One was the Morose Avenue, or the Cobblestone Place comprehensive permit that this board approved, and that added 5 additional units to the SHI. And the other project involved 255 Princeton Street, which is not a comprehensive permit. It was done through other zoning means, but as part of the agreement for that development, there were 6 what are called local action units that the town applied to the Executive Office of Housing Livable Communities to have the SHI updated. All of that paperwork was submitted to the Executive Office of Housing Livable Communities well before when the present application from Riverneck Road was filed with the town. In fact, we have received an updated SHI from the state dated May 22nd, which I recognize is 4 days after Riverneck Road filed their 40B application. But again, all of our paperwork to the state was in prior to this application. And the updated SHI reflects that we are now at 10.02%. So we have just squeaked past the 10% threshold. So the board is in a position that if you should choose, you can invoke safe harbor. And for those who didn't hear my explanation at the last hearing, just because you've achieved safe harbor doesn't mean you cannot consider another 40B application. It simply means that if you choose to invoke safe harbor, you can either deny this application outright by virtue of the fact that you've met the safe harbor, or you can go forward and you can consider the application of Riverneck, 243 Riverneck LLC, and ultimately reach a decision on its merits. Either way, whether the board ultimately approves it, denies it, or approves it with conditions, because you have invoked safe harbor, the applicant cannot appeal the zoning board's decision. Now, if you decide to invoke safe harbor this evening, it would require a vote of this board to do so, and then that would trigger a process where we would have to submit notice to the applicant and to the Executive Office of Housing and Livable Communities, letting them know that this application has come in and that we feel we've achieved a safe harbor. The applicant has the opportunity, if they so choose, to challenge whether we have met that safe harbor. And if that is the path that the applicant chooses, then there will be a separate hearing before the Housing Appeals Committee at some point, the Executive Office of Housing and Livable Communities would first have to decide who they agree with as to the 10% threshold, and then whoever is not happy with that determination could seek a further appeal of the Housing Appeals Committee. That process, however long that takes to play out, eventually will result in a decision. And if ultimately the decision is that we've achieved safe harbor, then if the board has similarly chosen to deny the comprehensive permit on that basis, that process is over. If the board chose to continue this hearing and consider the application on its merits, then following the determination on safe harbor, it would come back to this board for a further hearing to decide the case on its merits. So that's a lot of information right there, but really what the board needs to determine as a threshold matter is whether you wish to invoke safe harbor, and then depending upon the outcome of that discussion, we can discuss whether or not you want to deny this outright or whether you want to consider the application on its merits.
Thank you. I guess I'm going to turn to the board and say that on 3 Crosby Lane, we made the decision to declare safe harbor. I would ask for a motion to determine whether that's still the fact with this one. I don't know, it could have changed, so we can look at it, but it seems we've already chosen a path to claim the safe harbor. I don't think stepping away from it now is the best idea.
I agree with that.
Yeah, I'm in agreement with that.
Would someone like to make a motion?
Make a motion to
Mr.
declare.
Chair, before the motion, if I could just be heard briefly, Matt Provencher, I represent 243 Riverneck.
I'm going to ask Caroline if that's the right course.
It is your call, Mr. Chair.
I think we're going to go ahead and let you speak. I hope you'll be brief.
Sure, I very much appreciate it. Thank you, Mr. Chairman, members of the board. Matthew Provencher, I'm here for 243 Riverneck LLC. I'm also aware the property owner and Mr. Patel are both here. I believe the property owner wishes to speak. Of course, it's your choice whether to recognize him, but I just wanted to make it clear before you entertain to vote on the motion. As you indicated, I'm going to keep it very brief. I just wanted to say that it's the position of the developer that in this circumstance, if you're going to make a decision about whether to invoke the safe harbor position, we would be amenable to you doing it immediately. I think that continuing the hearing, proceeding with a presentation on the full merits of the proposal, only to have the safe harbor provision still as an active issue out there, it makes sense to resolve it for everybody up front so that we're not spending time, expense, and effort looking at and presenting issues and discussing them at great length when they're ultimately not going to be relevant to the board's decision making. So I just wanted to make that clear. If that's going to be the direction the board is going, we understand that. We may have some issues and disagree with you, as your attorney advised you, but we can deal with those at a later date. So if that's where the board is going, I appreciate it. To whatever degree the board might be inclined to continue this matter, I would just ask that because we don't have the entire project team here tonight to present to you because of the safe harbor issue, we'd ask that you continue it to another date so that we can make a more full presentation with all of our project consultants at hand.
Understood.
Thank you very much. Appreciate it.
I guess we'll go back to the motion. We would like a motion in the affirmative.
I would move we invoke safe harbor.
Can you just stretch out a little to 243 Riverneck Road?
Yeah, to 243 Riverneck Road, Chelmsford,
For a comprehensive permit?
for a comprehensive permit.
Might as well get it right. Do I have a second on that?
I'll second it.
Second by Peter. All in favor?
Aye.
And all opposed? And Danny's not voting, so it's unanimous. With that, this will end up in court.
If I may, Mr. Chair, then
Now we have to vote.
the second question would be, does the board wish to deny this comprehensive permit this evening
Because we entered.
because you've achieved the safe harbor, or do you wish to, as Attorney Provencher just asked, continue the hearing to another date certain to hear the merits?
With my understanding, if we invoke safe harbor, you did not want a continuance, is that correct?
Well, as I said, I think it's open. We could continue this by agreement while you do that if we want to go down the process of challenging and determining whether you validly invoked safe harbor. But I think this is really up to you. We're going to join issue on that one way or the other. And as your attorney indicated, the eventual end result would be we'd come back before the board. So my position is just, I'm fine with whatever you want to do.
We invoke and vote to deny this evening. If we invoke safe harbor tonight and vote to deny, it wouldn't go back to us necessarily. It would go to, I think, Housing Court, is that correct?
Right.
And then they would make a determination based on, did we fairly use safe harbor? And would it come back to us? At that point, it would come back, and we'd certainly, accept a full presentation.
Exactly. That's
Okay.
where I'm at.
So I guess I would look for another motion to deny the application at 243 Riverneck Road.
Do I have to vote it in the affirmative and then vote no?
You would, if we vote to,
Because aren't motions supposed to be in the affirmative?
In technically speaking, in parliamentary procedure, yes, but it's perfectly acceptable to, if it's more clear to everyone, to vote to deny this because the town has achieved safe harbor, that's fine.
so we won't need this in the affirmative. Someone like to make a motion?
Motion, I'll read what Evan has written. I move that the board has determined that the town of Chelmsford has achieved one of the statutory minimums set forth under General Laws, Chapter 40B, because the town's subsidized housing inventory, as maintained by the Executive Office of Housing and Livable Communities, comprises more than 10% of the town's total housing units. As of the date the application for a comprehensive permit was received from 243 Riverneck Road, LLC, for the property located at 243 Riverneck Road. Further, that the board authorize the chair to finalize, execute, and send written notice to the applicant with a copy to EOHLC to invoke the 10% statutory minimum within 15 days of the opening of June 18, 2025, public hearing on the application.
Could I get a second on that? Did you have a question, Dave? Second by Glenn. All in favor of denying the application?
Aye.
It's unanimous. The application is denied. To those here, that means that this application at this point is no longer with the Board of Appeals. There's going to be a court hearing, assumedly, where they decide whether we have fairly invoked safe harbor. And at that point, if we have or haven't, it would come back to the Board of Appeals. So at this point, the hearing is going to end.
Make a motion to adjourn?
Second it.
I only read this motion. Motion to deny.
Motion to adjourn? All in favor?
Aye.
Unanimous? Thank you all.
Are we supposed to take?